My name is Jeff Kravitz. I am the co-chair of the ADR section of the Beverly Hills Bar Association. And today we're going to be talking about using experts at mediation with two folks who know it well. First is John Hanover. He's a mediator and an arbitrator with ADR Services, Inc. He brings over 37 years of experience in construction litigation and dispute resolution. John is known for his pragmatic solutions-oriented approach, and he has represented clients in complex construction disputes across trials, arbitrations, and mediation, and previously held leadership roles at a major law firm as general counsel for an international engineering project, management and construction services firm. He's going to be joined by Bob Mann, my former colleague. He too is a mediator and an arbitrator with ADR, and he's known as one of California's top dispute resolution professionals with deep expertise in real estate, business, and construction matters. He is a former trial lawyer with over 70 verdicts and extensive project management experience, bringing a unique blend of technical knowledge and practical insight to even the most complex and contentious disputes. So, gentlemen, I've been looking forward to this. Let's roll. You've got the floor.
Okay, thank you, Jeff. It's so good to see you. Welcome, everybody, to our webinar on how to use experts effectively in mediation. Thanks to all of you for joining us today, even though we can't see you. This webinar came about because a lawyer in a case about a month ago called me a couple of days before the mediation, and he said, "Do you think I should bring my expert to the mediation?" And I thought to myself, I don't think this person has much of a plan or much of a goal. And I thought about it. So I wrote an article about that whole concept for the Daily Journal. The Beverly Hills Bar Association saw it, called me and said, "Would I do a webinar?" I said, "Absolutely." So here we are. So our presentation today is in the context of a construction dispute because so many of those disputes are expert driven. And as my colleague John Hanover will explain, our focus today is on using experts effectively. And we're trying to frame this discussion in two ways. The first is as goal driven, as John will explain. It's goal driven. Set a goal and work that goal. And the second is, in addition to that goal, we're trying to give you practical information that you can use in a practical way to do better at your next mediation. So let's start with our four-step plan. So John, let's talk about our four-step plan.
Will do, Bob. So thank you and good afternoon to everybody. I'm John, and it is my pleasure to be here with my friend and my colleague, Bob Mann, to talk about the use of experts in mediation. And Bob's right. When Bob got that question and he invited me to join him in this mediation, we started thinking about how best to use experts in mediation. And we didn't really want to talk about it in the sense of nuts and bolts or a mechanical system necessarily for using experts. We really wanted to think about it strategically, and that took us ultimately to the four-step plan that's on your screen now that Bob and I devised. And it all starts with, number one, setting the right goal, and that is the strategic element of putting together something that's going to get you to step four, achieving the right result, as long as you retain the right expert and you prepare the right way. So following these concrete steps, we thought that really is the ultimate success roadmap for getting to a result that you have planned for and hope to execute at the mediation. So with that four-step plan, Bob, the first is obviously setting the right goal. So next slide, please.
Okay, so let's think about what typical goals are in mediation. We can start with maybe the easiest, unproductive goals. What are unproductive goals? Going through the motions, checking off a box, some court-ordered mediation where you've got to report back to the judge, okay, we had a mediation. If that's your goal, then you can probably skip the rest of the webinar because it's not really going to be expert-driven. So what we want to talk about are more productive goals, such as what do we really want to accomplish? What's the goal? Is it to develop information? Is it to exchange information? Is it to confirm information? Is it to narrow the issues? The next one, very, very important. Is it to influence a future conversation that will lead to a resolution? Or is the goal to achieve a resolution? That's kind of the end game goal of all of these things. So let's think about how we use the experts effectively to accomplish these goals. So let's say your first goal in a mediation process is we want to develop information. So how do we use that expert effectively to do that? I think that the first step for you as the lawyer is to meet with the expert, sit down, explain that's my goal. We need to develop information in this case. We're lacking information, and then map out a strategy to achieve it. So, for example, if that's your strategy, you don't want to simply say to yourself, well, I need a construction expert or a delay expert or a damages expert or expert care expert, standards expert. This is very, very specific. So how does that expert effectively develop information? The answer is by asking questions. Which subcontractor did this work? Are there plans? Are there permits? Are there subcontracts or just purchase orders? Is there insurance? What is the big picture of this project? Did the owner run out of money? Is this a project that failed because the plans were no good? Were there unforeseen site conditions? The task of obtaining and developing information has to be both big picture and granular at the same time. What if you want to exchange information as a part of educating the parties about the case? There's two concerns about effectively exchanging information. The first is timing. The second is transparency. There's no secrets in these cases. The sooner you publish information, the better. This is a recurring theme that we're going to be talking about today. Transparency means publishing the essential documents in these cases: defect lists, cost of repair estimates, testing reports, reports of consultants. How do you confirm information? If everybody is trying to get on the same page about the basic facts, an effective expert goes about that by confirming information. Here's an example. Perhaps there is some lack of clarity about the scope of work. Maybe there's a stucco problem in the case, and the expert needs to confirm what's being recommended here. You want to take all the stucco off this building, a portion of the stucco off this building? Do you want to, for example, remove all the windows that were tested or every single window in the building? So this is confirming information. So your expert's got to be focused on that. The last thing, almost the last thing in this slide, narrowing the issues. After you develop the facts, an effective expert narrows the issue. Construction cases and a lot of other cases sometimes start like this, then they get really big, and at the end you have to bring them back to this. You have to make them smaller again. We think that the most effective way to narrow issues is expert-to-expert meetings, preferably without the lawyers. Those meetings you might think about as a sort of a friendly deposition. What if you want to influence a future conversation, which is a very important goal in this process? If that's your goal, the effective expert focuses on two things. If you represent the plaintiff, that expert has to focus on raising expectations on the defense side. If that person is representing the defense side, that focus has to be on lowering expectations on the plaintiff side. So here's the most important point about that. An effective expert raises or lowers expectations by saying things like, this is why that can't be done, or this is why we have to do this in this certain way, as opposed to saying things like, we're just not going to do it that way, because that's not helpful. This is why we're going to do it this way. The last issue, reaching a resolution, this is all homework. And then at the end, this gets you to reaching a resolution. So let's look at our next slide. So this is about how to choose the right expert. So how do you choose the right expert? Well, these are the qualities, but remember, all of these qualities relate to your goal. So let's look at these in order. A good expert is articulate because to be effective, an expert has to tell a story. They have to be able to communicate complex ideas in an understandable fashion. Experts who wander through presentations and digress, maybe tell war stories, are typically not effective. An effective expert is a consensus builder. This is a key aspect to this in my view of the world. I usually use a firefighter metaphor. An effective expert brings a fire extinguisher to a mediation. An ineffective expert brings a gallon of gasoline to pour on the fire and just makes the fire bigger. Experts have to be flexible. Oftentimes, opinions and focus has to change over time as the facts change. Economic realities can change opinions and focus. For example, a lack of insurance from a key party requires you to shift your focus to other parties. An effective expert is nimble and flexible. Let's think about persuasiveness for a minute. There's a big difference between knowing something and persuading someone else to see it the same way that you see it. Really, it's a sort of a combination of art and science. It's a merger of technical mastery with storytelling. But persuasiveness is very, very important. Sometimes the most effective thing an expert can do is simply say nothing. Sometimes silence is the best thing in a mediation. While people are saying things, it's better to just be quiet and listen. This can be very, very persuasive in a kind of an ironically silent way. And it's part of being effective. Here's the last thing to say about this particular part of the slide. You might ask yourself, well, okay, I need somebody who's articulate and persuasive and builds consensus and is flexible. But what if I haven't used this person before? How do I find out if they have these qualities? I recommend you sit down with the expert that you're thinking of hiring and you say to him, this is what this case is about. This is my goal. I want to persuade somebody about this. How would you do it? Tell me how you would approach it. And listen to what that expert says. Are they articulate? Are they persuasive? Do they have a mastery of the technical aspects of the case? Can they tell a good story? I think that will help you. Let's have our
And then,
next
Bob,
slide.
yeah,
John, did you want to comment?
no, let's go to the next slide, and I'm gonna comment on what the bad expert looks like, because the good expert that you've described is one who understands the goal after you've set the goal and you've strategically planned how you're going to conduct the mediation. And if you find an expert who you qualify as a good expert, you're in great shape. But if you go to mediation and you happen to have a bad expert, which I've seen many times, you're going to end up with someone who can't do what you need to do to advance those strategic goals. And the first point that you made, Bob, was you really need somebody who can crystallize that knowledge. But I've seen experts who are so deep in the weeds, are so interested in their own kind of curiosity about details of the case that they're unable to crystallize that knowledge and communicate what should be a concept that's very persuasive. I kind of think about it as a jigsaw puzzle. Oftentimes I'll see experts who are very good at identifying the edges of the piece and can describe the piece very well, but cannot take that piece and put it into the overall puzzle so that you end up with a picture. The bad expert just isn't capable of doing that. The second trait I've seen as a bad expert is someone who's not authentic, who doesn't come across as authentic. And that's part of the conversation you just described, Bob. At the same time, you're listening to how that person would tell the story, you're judging, you're identifying the characteristics that are going to make that expert either effective or ineffective in mediation. And if the expert really doesn't have the subject matter expertise, hasn't done the homework, feels uncomfortable in that setting, isn't in sync with counsel, they're going to come across as inauthentic, and that's not going to be helpful in the mediation. In terms of the flexibility and being able to really change course or to monitor the proceedings and then use the best techniques and the best information they have, I think about that. I guess I have a lot of analogies, but I think about that in terms of golf. Not that I'm a great golfer or even would ascribe to a golf method, but right. But even with that frustration, I'll use the analogy of a bag of golf clubs because there are 14 clubs ranging from a putter to a driver. One to hit the ball a very short distance, the other obviously to hit the ball a very long distance, and everything in between. And if a bad expert only has one club, in my mind, a bad expert only has one speed, only has one tone, one level of aggression, one focus, cannot pivot when necessary during the mediation, and comes, frankly, in a confrontational way, looking for a fight, which at the mediation, that's really not shouldn't be the goal of anyone who's coming there to achieve one of the results that Bob identified and we've talked about in terms of setting the goal. So most appropriate, I think, is the expert who can read the room. And if you have someone who can't and makes inappropriate remarks at the wrong time or uses analogies or facts that really don't support the goal that you've identified, you're going to end up with a very ineffective and unproductive expert. Now, it could be worse. You could end up with the ugly expert, and Bob's going to describe that. And we're going to talk about a few situations that really derail a mediation as opposed to just aren't supportive of the goals that you've identified. So next slide, please.
Okay, thank you, John. Well, you got to love this slide. Before we say anything about it, I just love this slide. Yeah, but the great part is somebody loves this animal, which is even better. So let's think about this for a second. Bad reputation. There are experts out there who have bad reputations. How do you find out? Ask around. Ask other lawyers. Ask other experts. What do you think about this person? Do they have a good reputation? Have you dealt with this person? You can find out a lot of stuff. Has this expert ever gone on the record with contrary positions? I'll tell you a very, very short war story, if you will. Many years ago, my former partner and I tried a big case against a stock brokerage company who looted an account. In the middle of preparing for the trial, I found an appellate case where they had referenced the expert, except in that case, he had testified. He was the defense expert in our case, but he testified for the plaintiff in that case. I called the lawyer. He had the trial transcripts, and he sent me a copy of them. And I read the transcripts, and lo and behold, the 20 things that he said in our case, he said this, and the other case, he said that. At the trial, I read the transcript for 2 hours. That's all I did. I never asked him a single question. I read the transcript for 2 hours. It destroyed him. It was my finest moment in 48 years as a lawyer. And very shortly thereafter, they settled the case for $11 million. So it's a good idea. Have you ever testified in a deposition or in trial before? Ugly experts transform themselves from experts to advocate. I think effective experts need to stay in their expert lane. There are honestly few things more disruptive than an expert who takes on the mantle of lawyer, judge, jury, expert, all these things. An expert is there to offer expertise. They can advocate for that position within their expertise, but it's not a good idea to have them start looking and acting like lawyers. Experts who inflame clients. Last week, I was in a mediation, and the expert had a lot of really, really, really bad photographs, meaning alarming photographs. Every time I went into the plaintiff room in that case during a full day mediation, the expert had the photographs on the screen. And I thought to myself, I can almost see the client's blood pressure going up looking at these photographs. It was very, very counterproductive. So you have got to be very, very careful. You can advocate and talk about things, but it's a bad idea to inflame the client. Similarly, experts who create unrealistic expectations impede resolution. I've heard experts say things like, well, they're never going to talk their way out of this one, or there's absolutely no excuse for this defect. Or they say to a client, don't worry, you're going to get everything you are asking for. Well, not only is it inappropriate, it's counterproductive to a resolution. Lastly, alienating others. Remember, consensus building is really, really important. Somebody who alienates other people and aggravates them, sometimes even the mediator, it's destructive. I've had experts call names. He's an idiot. I've had them in meetings. Let me tell you something. I'm right, you're wrong. That is not helpful. That is not helpful. It's not effective, and it's counterproductive. The last thing is a quick note on using repair contractors as experts. And I'm going to put this under the heading of the ugly. I don't think it's effective. Here's why. A repair contractor has a built-in conflict because the more repair work that person does, the more money he makes. So he has to justify every dollar of repairs. I think that using a repair contractor as a percipient witness to talk about what he or she encountered is fine, but you're probably better served by retaining another expert to talk about the why, the what, and the how much. Here's the very, very last thing on this, really ugly. A long time ago, I represented the developer of the Shutters Hotel in Santa Monica in a very long arbitration. After many years of fighting around, we finally got the contractor to produce what we knew was an agreement between the contractor and the lead expert, who was the project manager on the project. Well, guess what? Lo and behold, the agreement said that this witness, who was their lead witness in the arbitration, had a contingent interest in the outcome of the arbitration. I can tell you, the arbitrators never believed another word that guy said. That was the end. So you want to be careful. It seems very obvious. That was a multi-million-dollar case. Everybody was astounded. So these things happen. Let's look at our next slide.
Thanks, Bob. So, yes, those are great examples of the ugly, and even the trial examples, I think, are appropriate examples for the mediation, because the same thing happens. You can have the same expert who's going to lose all credibility in a mediation and suddenly become very ineffective, or a bad expert in terms of trying to move the case towards one of those goals, whether it's information exchange or influencing the other party or achieving a resolution. So what does a good expert do? How are the party's going to be best served by a good expert who is there to build consensus, who is collaborative, who isn't trying to inflame his client, etc., or her client? What the good expert is going to do is to weave a story based on the potential liability of the parties. And whether plaintiff or defense, typically, at least in a construction case, that expert's going to be dealing with the liability questions here on a breach of contract or strict liability, negligence, etc. So if you're starting from the idea of asking the expert to assist you in the mediation by achieving one of your goals, you have to tie that goal to these theories of liability as well. So if it's a breach of contract case and you want to have the expert talk about the scope of the work, for instance, in the contract and how that scope might have been breached, you need to do it in the way that's going to elicit or further the goal that you have. If it's the goal of exchanging information, then again, you're going to identify what the contractual requirements are, but then have the expert ask questions and ask questions about what that scope was, how it may have been changed by the architect, what the discussions were on change order requests, etc. Same thing for strict liability. If you've got a strict liability case, and for instance, you're dealing with SB 800 and a right to repair, you're going to weave that into one of your other goals so that the expert can tell that story effectively. And an expert who can do that is going to be worth his or her weight in gold in mediation, because that's ultimately what is going to be persuasive. Same thing for negligence and standard of care, which I kind of equate the same. Tying that to one of the goals will lead the expert to talking about what a person in the locale who has that experience would have done in either executing the work or repairing the work, if that's going to be the key issue. But you're going to need that expert to be able to describe exactly what should have been done and how it was not done in that particular case. That may relate to a code violation. There's an example Bob and I talked about where there's a particular element, a weep screed perhaps, that needs to be installed on a particular building. There's a code that's specifically a building code that specifically addresses how that's going to be installed. And if that isn't done correctly, then that tells you what story the expert needs to tell. And so being able to put those together, being able to identify with the theory of liability what that story is going to be the most effective. Next slide, please.
So this is a continuation of this concept of the expert telling a story. And the kind of the umbrella over these more or less granular things, the umbrella is to correlate the story with the expert's preparation. In other words, it's back to our central theme. What's the goal? The goal dictates the expert's focus and preparation. So for example, let's say, and we're going to spend some time on this slide because these are very common tropes in construction disputes. So let's say, look at the second one, betterments and improvements. I'll give you a great example of this. Last week, in the same case where the plaintiff's expert was showing all the alarming photographs, all the defense lawyers sent me briefs in that case, and they all said the same thing. This case is about betterments and improvements because it was a money spent case, meaning the plaintiff had already spent the money to have the house repaired. All of that money had spent, all the repairs had been made. So how do you defend a case like that? Well, you argue betterments and improvements, and everybody said this is a betterments and improvements case. So what does the effective expert need to do in a case like that? Need to focus on a close analysis of where are the betterments and improvements. So you have to take the original plans, the repair plans, do overlays, put them on top of each other, use color coding to show the changes and the betterments, photographs. There were some very effective photographs showing the before and the after about how they sort of transformed this house from a nice house into a sort of a Taj Mahal. So the point is, it's back to the question of focus. If it's an estimated cost of repair case, the analysis has to focus on scope and method, because scope times method equals cost. So an effective expert will have a detailed analysis of scope and a reasoned explanation for method, emphasis on reasoned. An effective cost of repair presentation, unfortunately, because it's time consuming, but by definition, it has to be granular, sometimes painfully granular. But the important thing to understand is when an expert comes in and he does some 30,000 foot analysis, it's usually unpersuasive and ineffective. If it's a delay and disruption case, for example, it's not usually effective for an expert to show up and say something like, well, I stuck my thumb in the air and I concluded there's 235 days of delay and it's all attributable to the owner. That's usually not going to be very persuasive, especially because most people in construction cases know there's usually plenty of blame to go around. And that kind of assertion is not going to carry the day. So this is a very important point. The delay analysis, generally, more generically speaking, is a very, very specialized field. There's only a few qualified experts who do this work. That's not usually the problem. It's not the problem of finding somebody. There are good experts out there. The problem is it's expensive. A delay analysis is very, very, very expensive. And oftentimes people don't want to spend the money to do a deep dive. And the expert is forced to come into a mediation with a rather superficial analysis of the situation. And it's not going to be very effective. So that's an example of how an expert who might in a different setting be extremely effective becomes ineffective because somebody has put that expert on a leash. One other thing about this, I have found that it's particularly effective and very, very persuasive when a qualified expert comes in and says, here's a signed contract. I signed this contract. I will do this work. Very, very, very effective. I remember one case where a contractor came in and said, here's a signed contract, I'll do the work. I was skeptical that he could do the work for that amount of money. And I asked him about it, and he said, I'll do the work and I'll make money. And I'll tell you why. I've done over 5,000 houses that have this same problem. That's an effective use of an expert. Here's the last thing on economic loss, which is one of our bullet points on this slide. Economic loss, form of lost rents, lost profits, other strictly economic damages. These kind of damages require special expertise. The key to having an effective expert is to have your economic loss expert work closely with your construction expert, because your economic loss claim is almost always time-driven. So your expert needs to be able to convincingly and persuasively say, this is why we're going to have 6 months of lost rent, because it's going to take 6 months to fix this building. So they have to work closely. So John, maybe you can pick up some of the things on the right-hand column.
Let me talk about those on the right hand, and let me emphasize, Bob, that I think damages and a mediation is somewhat people are underprepared for that discussion of damages. I think people spend a lot of time on liability. They discover the facts. They've naturally spent a lot of time in the litigation leading up to the mediation, trying to discover the facts, and damages really need to have the focus and the attention that they deserve, because that's going to be what ultimately might result in achieving that resolution of the case. And so I do recommend that those experts be the most prepared and the most able to address each of the things, Bob, that you've identified, each of the elements of damages that you've identified in column 1. Column 2.
One thing, John, to that?
Yes.
It's sort of granular, but very important. See these 2 line items that talk about defense cost of repair on defense scope and cost of repair on plaintiff scope? Very often defense experts come to a mediation and they have a good defense cost of repair, but it's only on the defense scope. And the plaintiff says, well, that's not helpful because you're rejecting our scope. So I think an effective expert will have a defense cost of repair on both the defense scope and the plaintiff scope. And I agree, John's focus on damages is highly important, highly important. Remember all the buckets: liability, damages, and intangibles.
Right. And that's part of that expert who can really be flexible, who can really see the case from all sides, who can recognize the gray in their cost of repair and say, that might not be the only way to fix the problem. And I'm gonna draw from the plaintiff's experts and that cost of repair as well. Now, some of these damages, so looking at the right side, the additional living expenses ties to exactly what that cost of repair is, and or I'm sorry, what that repair methodology is and the time that it's going to take. But in addition, you're going to have an expert who can really say what the market conditions are, how those additional living expenses are going to be incurred, what the actual pack up and the pack back is going to add to that expense so that you can factor that into the overall damage calculations in a construction case. Same thing for loss of use, but that loss of use could be even more complicated. I've had cases where you might have a mixed use building, where you have retail establishments in a commercial building, you have apartments or condos, and so the sales might be delayed. You have interest rate fluctuations. And even I had a case where we were discussing a football stadium that was being delayed in construction, the Levi Stadium in San Francisco. The problem there is, of course, if you're going to miss a season in the NFL, you're going to have a lot of loss of use. And so trying to factor that into the calculation of what those damages are takes a highly specialized expert and someone who can opine about all the particulars in a sports arena that might be lost ticket sales from popcorn sales. And so doing that is really critical.
John,
The resultant damage,
it's the greatest
yes,
statement I've ever heard. If you miss it, you might have some loss of use.
yes, I think
Yes,
so.
like a few
Um,
$1 billion worth, maybe.
yeah, exactly. You are going to have a serious problem on your hand that's caused by a construction delay. Um, Resultant damage, I think that comes into play for a variety of reasons. One is typically that's the trigger for insurance coverage on a commercial general liability policy. So any expert who's going to be testifying in a construction mediation or offering an opinion in a construction mediation is going to need to be mindful of how to determine resultant damage and what might be covered and what might not be covered. And Bob and I have talked about that. Bob's example, which I'm going to steal right now, is to have the Three Stooges as the painting contractor that you've hired to do work. And you have Mo walking in with a can of pink paint for this residential single family residence that's going to be painted, slips, spills the pink paint, and then Curly trips over or slides in the pink paint, has a ladder in his hand, turns and breaks a window, and that's going to be your resultant damage from the work of the contractor who did not who had that negligent act in spilling the paint. The other point there is if the paint's pink and the contract calls for a white paint job, that's not something that's going to be covered by insurance. That's something that's going to be a breach of contract and the scope not being followed. So you may have damages for that, but you're not going to be triggering insurance coverage on that. Whereas breaking the window, which was the work of another sub, would be generally covered by that policy. The other areas that you're going to get into and your expert's going to need to be able to opine about are the water damage, which in my mind is always the easiest to explain and the most understandable in terms of insurance coverage and defective work. No matter where the water comes in, if it's from a roof or it's a window or it's bubbling up from the foundation and it's leaching into the floors, that water is going to cause resulting damage either to drywall or to other roofing materials or even to furniture or furnishings if the water is flooding the house. And so water damage is a great example where an expert can be very descriptive, can use photos, can use videos of that damage, and that is going to immediately get the attention of the other parties and be something that the experts can work, the mediator can work with in order to trigger insurance coverage and start talking about a potential resolution. Rip and repair or rip and tear is another area of damages that's frequently debated, at least in construction mediation, because some items that need to be repaired might already be covered with work that was completed correctly, but is going to have to be damaged in order to get to the defective work. So an example is an HVAC system that's not functioning properly. It's already been installed in the ceiling. The ceiling has been installed, or you have other ductwork that's running down walls or through spaces between the ceiling and the roof. And you're going to have to get at that, which might be a very expensive exercise of going through materials that have been completed. There's a lot of case law of that, whether that's going to be covered or not, but your expert is going to need to be able to describe that work in a way that makes it very apparent that there's no other way to make that repair but to destroy other work and work of other subcontractors, because that's going to trigger the coverage. And then intangibles is also a somewhat debated topic, but many of these that we've already talked about in terms of economic loss, loss of use, even loss of reputation for a business that may be delayed in their opening, are intangibles that can add to the value of a settlement and are something that an expert is going to need to be prepared to tell that story about. So let's continue, Bob, on the next slide on finding the drama of how to tell that story, because that ultimately is going to be what the expert is going to need to do and can dramatically shift the results of the mediation by using the right photo, by using a model, a video, really using that smoking gun. And I think, the best story I have about that is an expert who had been retained in an EFIS case. That is a case that dealt with an exterior siding, a cladding on a building that was designed for a very low moisture environment. And it was supposed to be not watertight, but certainly to maintain a low moisture quantity in a substrate that was primarily made out of wood and wood chips and resins that was to hold that material together. Well, it turned out in that particular case that the moisture content was very high and the construction was not done correctly, and water was getting in from the roof. It was getting, from the weep screed in the bottom. And so mushrooms began to grow out of the sides of the buildings and into the apartments, because it was an apartment building with nearly 1,000 units. And so the expert, who worked closely with the with the plaintiff's counsel, had been able to use something also that's often overlooked, which were interrogatories, to find out what cases that manufacturer of the substrate had been in. And one of those cases happened to relate to a boat manufacturer. Now, you may have thought when you're looking at those materials, it's going to be irrelevant, it might not be helpful. Turned out that the expert, in looking at those materials, found one dusty box that contained probably 600 letters from people who had bought the boats, and that substrate had been used to make seat backings or on the floor of boats. And the letters, one after another, said essentially, this material should only be used for mushroom farming. And the expert was able to present that in combination with the pictures of mushrooms that were nearly the size of a cantaloupe growing into apartment buildings. And that was the drama that caused that case to settle almost immediately. And I know, Bob, you have another example on water intrusion that we'd like to share.
I'll give you two very quickly, two or three other examples. I was arbitrating a case down in Orange County involving a school. And on the last day of the arbitration, which lasted for weeks, I never have understood fully why it didn't happen on the first day. They water tested the building. And when they water tested the building, which was everything was painted white in this building, they used blue dye in the water. And they showed a video. The whole building turned blue. I mean, no exaggeration. The entire building turned blue. When that happened in the arbitration, it got very, very quiet in the room. Nobody said anything for about 5 minutes. And then all the lawyers said to me, we're going to go outside and talk for a few minutes. And about an hour later, they came back and said, we think we've settled the case. I'll give you two other quick examples. I had a landslide where a building fell down the side of a hill. My expert, who's very, very smart, said, I think I remember seeing this. And he tracked down footage from a news crew, a television news crew, and there was a video of the building sliding down the hill. It was incredibly dramatic. The last one was, we had it was mediation involving a landscape contractor, and the house was featured on one of these reality TV shows. And the landscape contractor on the air was saying things like, oh, I've got everything totally under control. It's under budget. It's all great. It's all wonderful. The expert said, I wonder if there are outtakes. And he went to the producer and found the outtakes. And in the outtakes, the contractor was saying things like, I am so over my head in this project. I have no idea what I'm doing. The budget is completely out of control. We're never going to meet the schedule. They put together a highlight reel and they showed it at the mediation. End of case.
End of case. Resolution achieved.
Yes.
Goal achieved. Absolutely. Let's go on to our third, which is the prepare the right way, Bob. So let's talk about that.
Okay, so here we're coming full circle to our basic premise, which is establish your goal, create a plan to work that goal, and then implement that plan. So it's kind of an annoying expression, frankly, but the annoying expression is plan your work and work your plan. I don't know why it sounds annoying. It does to me. Implementing the plan in this context means, first of all, explaining the goal to your expert. I don't say to the expert, give me a defect list, give me a cost of repair. Instead, you might say, look, this case is all about finding insurance coverage. I want you to concentrate as much as possible on resultant property damage. That's going to be the essence of this case. Or, for example, in a delay case, very common in delay cases that, especially in public contract work, that there are these very onerous provisions in the contract. If the contractor has a delay claim, the contractor's got to jump through all these hoops to document the delay claim. And it's got to be done right away. And if it's not done, it's waived and all this terrible contract language. So if that's the case, and you're representing, for example, the public entity, you're going to say to your expert, I want you to focus on the contract language. I want you to present this in the way of, this is what the contract requires, and this is what they didn't do. So it's a concept of being very, very careful at the outset to have a strategy and then implement that strategy. Let's take a look at our next slide.
And yes, with that strategy and the preparation, you go back to, what are you asking that expert to do at mediation? If the expert's being asked to develop information, then the expert is going to ask questions. not tell. So the expert is going to really get at the why and where did that happen? How did that happen? Who did what? Trying to really identify the details that are going to be necessary for the opinions to actually make sense and for that education to follow. Same thing with the exchange of information. I think the key there is going to be transparent and timely, something you mentioned before, Bob. But in order for it to be effective at a mediation, that expert is going to have to be transparent about what he or she knows, because otherwise there'll be nothing for the opposing experts to comment on or to share information in one of those methods that we're going to talk about in a minute that the mediator may use to really get at the dispute and to try to formulate some resolution of that dispute. Timely means unless those experts have made that information available before the mediation, it's not going to be helpful at the mediation. It's like being at trial and not being able to lay your hands on an exhibit within seconds. You might stand there for a long time and thinking you have the best piece of evidence ever, but if you can't get it in your hands and present it to the jury or to the judge in a timely fashion, it's going to lose all impact. Here, the expert's needs to be able to exchange that information in advance so that the parties and the experts can talk about it during the mediation. If that hasn't happened, it's going to be as if those great documents, that great report doesn't exist because it will be passed over in the context of the mediation. If the goal is to confirm the information, then the expert just needs to be prepared so that the expert can ask the specific questions that are necessary to confirm the information, to learn the information from the other side. And that's going to be the best preparation. It's not easy, it's not fast, and it's not cheap, but it's necessary if the expert's going to be effective at mediation. Next slide, please.
So we're going to talk about timing in the slide after this one, but a lot of this is so much about influencing a future conversation, and that conversation is the resolution day, the money day in the mediation. So I like to think about it using the following analogy, because I like some of you out there in the ether may know me from prior mediations and know I'm kind of a car guy. So I like to use the car painting analogy. If you are painting a custom car, the preparation for doing that is ridiculous. It's hundreds and hundreds of hours of sanding and cleaning and sanding and doing this. The actual painting, after you've spent 300 or 400 hours in the preparation, it's about 2 hours. That's all it is. It's the same thing in the mediation. That one day in mediation, that's painting the car. Everything else is sanding, cleaning, doing the body work, all of that stuff. So all of that preparation is intended to lead to a conversation, to mediation, to resolve the case. It's almost always lowering and raising expectation, lowering expectations on the plaintiff side and raising them on the defense side. So part of it's mastering the details and part of it's telling a great story. If the great story is this plaintiff has suffered, to use John's case, I love the mushroom case. These people are living in apartments where there's mushrooms growing. Look at these photographs. This is no way to live. If that's the story, tell that story. Have your expert tell that story. If the great story is these defects are egregious. Look, here's a video of water pouring through a ceiling when it's raining. I've seen those videos, by the way. They're very effective. If the great story is for every $100 that the plaintiff spent to repair this house, they spent $95 making it better and $5 making repairs, tell that story. That's your great story. This is where your expert can be effective. Figure out what story do we want to tell and let the expert tell that story. Let's look at our tee-up slide.
And I think going to the next slide, yes, there is that tee-up day and that tee-up process is incredibly important. And in most complex construction cases, you're going to need a tee-up day. So let's describe, Bob, generally going through the tee-up slides quickly, because I do want to talk about the last slide in terms of the mediation techniques and how the experts might be asked to participate in the mediation. So I'm going to let you run through those really quickly, and then I'll talk about slide 17.
Great. So tee up is all about timing. So insurance carrier, where's the money? Insurance money. Most of the time you're dealing with insurance money. Insurance carriers live in a very bureaucratic world. They live and die by rules, regulations, reports, multiple layers of authority. As a result, if you're going to succeed and get that money, you have to play by their rules. And their rules are mostly about timing. So what do you have to do? What does your effective expert have to do? Your effective expert has to develop this information in a timely way. They can't just dog it. They've got to be on the spot, and they've got to develop this information. They have to publish it clearly, convincingly, and timely. A defense lawyer needs to evaluate it and review it and write a report. The defense expert needs to evaluate it, review it, oftentimes write a report. The adjuster needs to think about it, maybe go to higher levels of authority to get more authority or set reserves in the case. Here's the best way to think about it. It's simple. Sooner is always better. Always. If you're going to have a tee-up day, these documents have to be sent out at least 60 to 90 days before that tee-up day. Otherwise, you're not going to be on the golf course. You're going to be someplace else. So an effective expert produces the reports in a timely fashion. Critically important. So we have a few minutes left. John, you want to jump to the next slide?
Sure. I think let's jump to, I don't know if we're going to jump all the way to 17, or there was more that you wanted to talk about, Bob, on the tee-up day at this point.
I think we've pretty much covered it. It's mostly
Okay.
about time and knowing what people need to see.
I agree. So let's talk about how the expert's likely to be used, which is slide 17 at the mediation, because I think if you're preparing that expert and you're looking at those goals, you need to take into account how the expert will participate in the mediation so that you can achieve that result. These are the ways typically that an expert might be used, either having a presentation, a joint expert session with or without counsel, or with or without the mediator, having neutral experts, on-call experts, and even the situation which I've had when the experts really are the ugly experts and aren't being helpful in the mediation, being asked not to participate or not to come back for day 2 if that's the money day, or not being participatory in some other way. But I think depending on what your goal is, the experts need to be prepared for participating in any one or all of these ways, because the mediator is hopefully going to be flexible and use each of these in a way to further that goal, which also gets to the point of it's helpful if the mediator knows the goal. And so communicating and being transparent with the mediator so that the mediator can use the tools available to achieve that goal is very, very important. And I don't know if you wanted to comment on any of these presentations, Bob, but I think just my key point is the experts need to be prepared to do any one of these. I think an expert presentation can be persuasive, detailed, and dramatic, but you have to read the room and know how long you have and what the next step is and what the purpose is. The joint expert sessions I've seen go completely off the rails, where it devolves into a shouting match between experts, which isn't helpful, as opposed to a collaborative effort where your expert and the other expert can say, yes, I agree on those items. Yes, that is the way to repair that. I think that cost is appropriate. Let's move on. Neutral experts may be used to bring additional information in that your expert would have to consider. And then the last is maybe it's not necessary for the experts to be there at the mediation, but be on call. And I know, Bob, you've had situations where that can be effective or be ineffective.
It's can be, yes, I think these are all very great points that John has made. If you're going to have your expert standing by, make sure the expert's in the office and not in his car. That usually doesn't work out too well. But the last point I would make about this is all of this, everything on this slide, it's all about timing. If you're having a presentation on what's supposed to be a money day, guess what? It's not going to be a money day. If you're having a joint session on a money day, it's not going to be a money day. And under the heading, John made an excellent point about sharing information with the mediator. I always ask the lawyers, is this a money day or is this a tee-up day? What are we trying to accomplish? I like to set the goal too, not just the lawyers and the experts, but the mediator too. I think it's very helpful because it's a collaborative effort. Well, let's see. My computer says it's 1:30. We may have questions. I have a question. My question is, how old is my photograph? I am not sure, but it's not recent.
I'm not sure. I might know, but I'm not going to comment, and we'll see if anybody emails in. I don't know if there's a prize for guessing that, Bob, but it's somewhere between a week and 6 months. I can't really say.
I
Um,
totally not more than that. I wanted to thank everybody for joining us today. John, thank you for working with me on this. It was, I think, an excellent presentation. At least I hope everybody thinks so. So thank you for taking the time to join us.
And thank you, Bob, and thank you to the Beverly Hills Bar Association for giving us the opportunity to present. And yes, I hope we've shared some things that will be helpful going forward. I know if there are questions, you can submit those questions. Bob and I will be happy to answer any questions that you may have. I know we didn't have time for questions given the amount of information we had, but we'll be happy to respond to any questions that are submitted by anyone who is here now or watches the presentation at a later time. So thank you all.
Thank you. It doesn't appear like we actually have questions at this moment. So I'd like to say thank you both, John and Robert, for assisting us today with today's program. If anyone in the audience today does have any questions, please feel free to direct them over to the emails provided in this slide. Thank you and have a lovely afternoon.
Thank you.